evening, and thank you for joining me on the Path to Liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, March 8th, 2023 at a special time in the evening. Yesterday, I had another episode all planned out, but I kicked that one down the line. I'll probably use it sometime next week because I got news yesterday of something much more important to cover. A federal court issued an opinion, not a ruling. Let's keep in mind, it's not everyone calls these things rulings. These are opinions of the court, that the entire Missouri Second Amendment Preservation Act, or SAPA, not just part of it, but the entire thing is unconstitutional. Now, most opponents out there, and I've been watching this very closely, not just today, but for many, many years, most opponents are saying things like, see, we told you so, it's unconstitutional, always was, blah, 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 it's garbage. But that ignores the fact that there's going to be an appeal process, and, well, there's much to talk about on that. And on the other hand, most supporters have been saying things like, well, the opinion is just pure political theater, it's a bunch of junk, it's going to get reversed on appeal. And while I think a reversal on appeal is very, very likely on almost all of it, I don't think it's not guaranteed. And there's some sections that might have a little bit of trouble. So if you want to understand what's going on, and, for example, compare how it relates to California's immigration sanctuary laws that were 3 that won in court just in 2020. Now, keep in mind, I predicted in a column over at The Hill in January of 2017, right in the first few weeks of January 2017, that the Trump administration was absolutely going to lose in its effort to take immigration sanctuaries through the federal court system, take their funding, et cetera, et cetera. And I absolutely called that, and I'm going to explain what happened there, what's different here, what's similar here with Missouri, and maybe even a little bit on state marijuana laws and Second Amendment protection laws in Arizona and Montana. The short version, Judge Brian Wimes, I think that's how you pronounce it, he's not claiming that the feds can force Missouri to help enforce federal gun control. He's claiming that a section, primarily one section, that defines what the state won't enforce is unconstitutional. It's an unconstitutional interference with federal agents, and therefore the prohibitions on enforcement that reference that particular sections, it's 1.420, no longer have anything to reference, because if that section that defines everything that they say, we're not going to enforce this, and then there's a ban on enforcement in another section, and then the one section is gone, then there's nothing to reference. And so therefore, well, law enforcement can, but they're not required to start working with the ATF again. It is kind of like threading a needle. I'm not necessarily surprised that this went down like this, but it's we'll call it a creative way of supporting the monster state. Let's kick this off. For those of you who are not aware, the Missouri Second Amendment Preservation Act is something that we worked on for 8+ years specifically, and we supported many good people in Missouri working to get that passed. It got signed into law in 2021 and went into effect in June of that year, and it bans any entity, and this is an article by Mike Meharry, it bans any entity or person, including any public officer or employee of the state, and its political subdivisions, from enforcing any past, present, or future federal acts, laws, executive orders, administrative orders, court orders, rules, regulations, statutes, or ordinances that infringe on the right to keep and bear arms. And they define what they consider an infringement on the right to keep and bear arms in this kind of very specific section, and I will get to that in just a moment. So far, so good. It's basically saying the state of Missouri, and I know the judge actually misread this particular section as well and claimed that the state was trying to ban even feds from enforcing these acts, but it's very easy to go through the legislative history and find out that that's absolute nonsense. But so this is pretty straightforward stuff. Missouri says we're not going to help the ATF enforce federal gun control. And there's a lot of history on this. For example, there's over 180 years of Supreme Court precedent. I should also mention 2 important things. One, this episode is not about my view of the original legal meaning of the Constitution, where all federal gun control is illegal, null, and void and needs to be treated that way. It's also not my view. I'm not going to be talking about my view that the ATF, the only thing it's authorized to do is disband, and we shouldn't trust the courts. Unfortunately, This law is in federal court. And once you're in federal court, you make those cases, you've lost. You make those opinions, you make those, take those positions, you're going to lose. So now that it's in federal court, we have to use the language that the federal courts will listen to. It's very difficult to win in their terrain sometimes, but it can actually be done. So there's over 180 years of Supreme Court precedent that backs up the notion that states do not have to use resources, person power, anything to help implement or effectuate any federal acts or regulatory programs. This is known as the anti-commandeering doctrine. It actually, well, I'm not going to get into the constitutional structure there. But anyways, here's some of the cases. I'll give some highlights here. Prigg versus Pennsylvania in 1842. Justice Joseph Story, and this is an article by Mike Meharry going over these cases. If you're watching and you want to follow along with what I'm talking about here, I publish a blog post usually about an hour to 2 hours after the live stream is done, probably sooner tonight because I want to wrap it up and get some dinner. But I publish a blog post over at 10thamendmentcenter.com/path2liberty. And in that blog post, there will be a show links section with tons of links for this episode here today. So if you want to learn about anything, read more in context of what I'm talking about, you'll find it there in the next couple of hours. So Meharry writes, in Prigg versus Pennsylvania, that's 1842, we're talking about Fugitive Slave Act cases. Justice Joseph Story held that the federal government could not force states to implement or carry out the Fugitive Slave Act of 1793. He said that it was a federal law, and the federal government ultimately had to enforce it. Now, it wasn't... Here's how he put it. He said the states, therefore, cannot be compelled to enforce them. Again, just straightforward stuff there. Then the next one that I want to cover is Sandra Day O'Connor in another case, New York versus U.S., 1992. She wrote, as an initial matter, Congress may not simply commandeer the legislative processes of the states by directly compelling them to enact and enforce a federal regulatory program. And she went further. While Congress has substantial powers to govern the nation directly, including in areas of intimate concern to the states, the Constitution has never been understood to confer upon Congress the ability to require the states to govern according to Congress's instructions. That's the first real modern anti-commandeering case in 1992, Sandra Day O'Connor. The one that most people cite is Justice Scalia for the majority in 1997's Prince versus U.S. case. And here Scalia wrote, the federal government may neither issue directives requiring the states to address particular problems, nor command the states' officers or those of their political subdivisions to administer or enforce a federal regulatory program, federal act, federal anything. So over and over and over, we're seeing that the federal courts are saying the federal government, I mean, they're giving them broad latitude on what they can pass. They're not really striking down any of these federal acts. But what they're saying is, well, it's ultimately a federal act. And if the states don't want to help you enforce it, that's up to them. And we're going to get into some more detail on this as well, especially how it plays out with Missouri, California, Oregon, and elsewhere. And the most recent case on this, well, at least at the Supreme Court, is Murphy versus NCAA in 2018. Here, Mike writes, the court held that Congress can't take any action that, quote, dictates what a state legislature may and may not do, and even, not in every single case, even when a state action conflicts with federal law. Samuel Alito wrote, a more direct affront to state sovereignty is not easy to imagine. So with that kind of foundation in the kind of the basis here, we know that the federal courts over and over and over take the position that the federal government cannot require a state to help enforce or implement any federal acts. That includes anything from the ATF, the DEA, whatever it may be. They can't do that. And surprisingly enough, right in his opinion yesterday, Judge Brian Wimes affirmed this very thing. Now, he tried again. He's trying to thread a needle while still affirming this, but trying to claim that it's all unconstitutional anyways. It's kind of confusing, and I'm not seeing anyone really get this, but hopefully this will make sense. Here's what Wimes writes. While Missouri cannot be compelled to assist in the enforcement of federal regulations within the state, so he's affirming this doctrine, it may not regulate federal law enforcement or otherwise interfere with its operation. So that's an important word, interfere, and we're going to get to that in just a moment. Now, this legal doctrine, anti-commandeering, it's a big part of why immigration sanctuaries exist. For example, the Oregon sanctuary state laws, what do they call it? Oregon, I forget the exact name of this, Oregon sanctuary promise laws. So I don't think this has ever been seriously challenged in federal court because no one thinks it's going to actually succeed. Because Oregon, here, for example, since 1987, it was the first state in the nation to pass a statewide law stopping state and local police and government from helping federal authorities with civil immigration enforcement. In the ensuing decades, the law was updated several times, for example, in 2017 and then again in 2021. Here they write, and this is on the Oregon State Department of Justice website, it is against Oregon law for state and local law enforcement or public agencies such as state and local government offices in the state of Oregon to participate directly or indirectly in immigration enforcement without a judicial warrant. So if the feds want help with immigration enforcement, Oregon just says no. They say it no all the time. And in fact, every time they're asked, they're required to put together a report and decline it, unless there's a judicial warrant, basically a judge's order saying you have to help with this. On top of it, and this is where Oregon actually goes much further than what is happening in Missouri, federal immigration authorities are prohibited from operating private detention centers, accessing non-public spaces and jails, and operating on court grounds. Now, it should be pretty obvious to you that if we're talking about Missouri saying we're not going to help enforce the federal gun control, we're not going to help the ATF, we're withdrawing from ATF task forces, and Oregon saying we're doing the same thing on immigration, but then on top of it, one could make the case that Oregon is actually interfering with federal agencies by saying that a federal agency has to actually not have private detention centers if they want it, or the federal agents are not able to access non-public spaces and jails or operate on court grounds. Missouri does not do any of those things in the Second Amendment Preservation Act. And the reason that this exists in Oregon, as of this part was passed, I believe, in 2021, is because a very similar part of the California Values Act, the immigration sanctuary state laws from 2017, those were upheld in federal court, and the Supreme Court basically said, we're not going to review this in 2020. I'm going to get to that in just a minute. Now, here in the Missouri Second Amendment Preservation Act, again, I'm going to link to all this stuff in the show notes. A lot of this is very technical stuff, but if you want to understand beyond just platitudes of administration dumb or gun grabbers dumb or vice versa, I'm sure there's not a lot of vice versa here, but if you want to understand the real details of it, I'm really going to get into it here. Now, the Missouri law, again, does the same thing as Oregon. It bans state and local enforcement of a federal act. Here in section 1.430, all federal acts, laws, executive orders, administrative orders, rules, and regulations, regardless of whether they were enacted before or after the provisions of this act, that infringe on the people's right to keep and bear arms, according to the Second Amendment and the Constitution of Missouri, shall be invalid to this state, just according to the view of the state, shall not be recognized by this state, shall be specifically rejected by this state, and shall not be enforced by this state. I'm very familiar with this language. The first version of this probably came from my head in about 2008 or so, before we even started doing this. Or section 1.450, no entity or person, including any public officer or employee, and this is what I was reading before, shall enforce any federal acts, laws, orders, rules, regulations, etc., as defined in section 1.420. Now, remember, the Oregon law, and also in California, upheld by the Supreme Court, directly regulates, even if it's just a small degree, saying federal agents are not authorized to do this under a state law. Now, if we tried to do that on a right to keep and bear arms, I can guarantee you that it would go nowhere in court. So you got to be a little careful about the political ramifications of these things. But these laws in Oregon and California do directly regulate federal activities, federal agents, things that feds can or cannot do. The Missouri does no such thing expressly. It does not ban any federal agent from operating any federal facility. If the ATF wants to set up an ATF detention facility, I guess they could. I mean, maybe there's some other logistics in that, but the Missouri law does not prevent them from doing that. It does not try to ban ATF agents from arresting people in Missouri courthouses or anywhere in Missouri. The closest thing that this law comes to trying to regulate a federal activity is in section 1.440, which I will get to a little bit later. This is the one that I think is going to go. It shall be the duty of the courts and law enforcement agencies of this state to protect the rights of law-abiding citizens to keep and bear arms within the borders of this state and protect these rights from the infringements defined under section 1.420. Again, well, I'll get to that in a moment. Now, this sounds reasonable probably to you and I. Yes, of course, if you're going to take an oath of office, it should be your duty to protect the rights and liberties of the people. But that's not how the courts are going to view it, and they don't think this is cool. Or here in section 1.450, again, no entity or person. I think the judge just severely misread this, probably intentionally, but I don't want to get into the whole kind of motives part of this anyways. So the question is, how do we get from laws like what's on the books in Oregon since 1987 and never even threatened with a federal lawsuit, California, which went through a bunch of lawsuits from 2017 through 2020 and actually won on almost every count, how do we get from that, where they're banning enforcement of federal immigration laws, to Missouri, well, also Arizona and Montana, they're not getting sued. Missouri's is a little bit more complex, so there are some attack vectors where they can take this to court, but a win would be a much bigger win. So it's we're playing a little risky game here, I think. But how do we get from where that is to where today we're using basically the same approach against the right to federal gun control, restrictions on the right to keep and bear arms? How do we get to that being unconstitutional? And I think it's important to understand how the administration filed this lawsuit last year. It was in February of 2022. First of all, I think it's a very political move. I know the feds don't like this. They complain about it heavily. The ATF doesn't like it. Of course, Merrick Garland and Joe Biden and the whole DOJ, they can't stand this. And I think that even if they don't believe they can win, they basically, as a political move, they have to do a lawsuit. And in the hopes of getting it in a friendly court where they can at least get a win on the board, they, of course, have an Obama-era appointee who took very much the same type of views that the DOJ took when they filed their complaint. So I think they just are out there trying to prove to their base that they're the good guys on this, and they're trying to stop the crazy gun nuts in Missouri. And I also think that's the same approach that the Trump administration took going after California. Now, once the law went into effect in Missouri, law enforcement agencies around the state started withdrawing from ATF task forces. And here from Mike Meharry's report on the initial complaint filed by DOJ, he says much of DOJ's complaints focuses on these severed federal enforcement relationships, noting that SAPA, quote, severely impairs federal criminal law enforcement operations within the state of Missouri. Now, it's not illegal for the state to just say, hey, we're not going to help. And if you can't do it on your own, too bad, so sad. In fact, Mike writes, he says, in the press release on the lawsuit, and it's linked to, maybe I can open it up here. Nope. I have too many tabs open. And now it's not going to load. Oh, here, the press release on the lawsuit begins with a statement noting that, quote, Missouri House Bill 85 makes enforcement of federal firearms laws more difficult. That's the whole point of the act. Everyone knows that's the point. If you withdraw support, and the feds, who only have about 5,100 employees for the entire ATF, a third of them are in administration, they can only close between 8,000 and 10,000 cases per year with state and local law enforcement helping them. The whole point of the act is to withdraw that support so it is more difficult for the ATF to do what they do. That is the goal. So we know the ATF doesn't like it because it's accomplishing exactly what we set out to do on day one. It impedes law enforcement efforts to combat violent crime. That Political garbage. It only mentions, Mike says, it only mentions potential constitutional ramifications near the end. They don't care about the Constitution, and they don't have much of a constitutional argument, although there are some interesting things that we do have to cover. Now, we do get a very political statement on these same lines at the end of Wimes's opinion from yesterday. And here's how he put it. SAPA's practical effects are counterintuitive to its stated purpose. Now, mind you, the name of the bill is the stated purpose. Second Amendment Preservation Act. The intent and purpose of the bill was to take a step to help protect and preserve the integrity of the Second Amendment, whether the feds are going to follow along with that or not. So that's what the intent is. And Wimes is incorrect on what he says the stated purpose. He says, while purporting to protect citizens, SAPA exposes citizens to greater harm by interfering with the federal government's ability to enforce lawfully enacted firearms regulations designed by Congress for the purpose of protecting citizens within the limits of the Constitution. Blah, blah, blah. Federal gun control protects you. That's the view that the judge is taking. And by not participating, this is interfering. Again, the key word is interfering. I will get to that in just a moment. Oh, it did open up the press release. Sorry, I got tons of tabs here. So let's compare yesterday's opinion with an opinion of the U.S. Court of Appeals for the Ninth Circuit, here from SCOTUS blog, talking about the California Values Act. Passed in 2017, SB 54, known as the CVA, prohibits state and local law enforcement officials from cooperating with federal immigration officials. For example, by providing information about individuals in custody or even transferring inmates in their custody to federal immigration authorities. So they're just like, they've got someone in custody and they won't even hand them over in some situations. And if that's not kind of thwarting federal enforcement, well, we got an interesting story here. The federal government sued California in 2018, arguing that SB 54 and two other state laws passed at the same time, AB 103, which I'll talk about, and 450, which I'm not really going to. They claimed that they were superseded by federal immigration law. Of course, it's always a supremacy clause. The U.S. Court of Appeals for the Ninth Circuit upheld the district court's decision not to block SB 54. This is the legislation that says they're not going to participate in California. There is, the Court of Appeals acknowledged, quote, and this gets back to what I was just reading from Judge Wimes. Judge Wimes is saying the Second Amendment Preservation Act is not about preserving the Second Amendment. It's about protecting the welfare of the people, whatever. I think in the long run, preserving the Second Amendment does protect the welfare of the people, but we don't need to have that political debate with some empire judge. But he's saying the problem here is that by not helping the federal government, it's making it more difficult for the federal government to enforce federal gun control. Okay, well, that's what we wanted. And here, on the other hand, the Ninth Circuit, the Court of Appeals for the Ninth Circuit said that no doubt SB 54 makes the job of federal immigration authorities more difficult. So they acknowledge it. We know it. It was the same argument that the DOJ made on this situation. But, quote, California has the right to refrain from assisting with federal efforts. And if they can refrain from assisting with federal immigration, they can certainly refrain from assisting with federal marijuana prohibition or the violations or attacks or regulations on the right to keep and bear arms. Now, here's the key difference. Again, Judge Wimes sees SAPA as interfering, and that is a very key word here. He specifically does not say what they said in the Ninth Circuit, that, okay, this is making it more difficult, but they are declining to assist. He's calling it an interference. And to be honest with you, even though I would love to see states interfere with federal agents all the time, and if we're talking about protecting and preserving the Constitution for the United States and the Constitution of each state, there is an oath that there's kind of a duty to do that kind of stuff. But that's not going to, there isn't a single court in the country, not one. There is a 0.00000% chance that any court would uphold and not strike down or have an opinion or ruling, whatever you want to call it, that a state actively interfering with a federal enforcement effort is okay. No one's going to say that. Things like arresting federal agents will always get shot down in federal court, or even requiring feds to get permission from a sheriff is very likely. Although these immigration opinions in California kind of open the door to some additional level of state regulation of federal agents, but I think we can get to that another time. So we can say the courts are wrong all we want, and I think they are on this type of stuff, but if every court takes that type of a position, we have to speak the language that the courts use in their territory. Now, here's how Wimes is trying to pull this off. Basically, thread a needle, call the entire act unconstitutional, while simultaneously not claiming that the feds can require Missouri to help enforce federal gun control. Check this out. Section 1.460, and this is from his opinion again, and 1.470 are each independently invalid as discriminatory against federal authority in violation of the doctrine of intergovernmental immunity. And don't feel bad if you've never heard of the doctrine of intergovernmental immunity. This basically goes back to that guy, John Marshall, McCulloch versus Maryland, where SCOTUS ruled that a state law that was taxing the national bank, basically the power to tax is the power to destroy. That's that statement there. So you can't have special regulations for the feds that will stop the feds. And that is the doctrine of intergovernmental immunity at its most basic. And so he says, Section 1.460 imposes a monetary penalty, it does, through civil enforcement action, it does, against any political subdivision or law enforcement agency that employs an officer who willingly violates SAPA. So basically, the law says these things you can't enforce. Any law enforcement, rather than punishing individual law enforcement officers who violate the act, which were in some earlier versions of the law or proposal, that had a lot of opposition and it wasn't going to pass. So there was a creative move to say, well, instead of actually punishing the individual law enforcement officers, let's have the sanctions against law enforcement agencies. We can actually tell law enforcement agencies, which are part of political subdivisions of the state, they exist at the will of the state government. The state government can tell them what kind of hiring practices they have. And in SAPA, they're basically saying, if someone enforces this as a state agent or as a federal agent, you're not allowed to hire them. And if you do this and knowingly do this where you knew they violated SAPA and you hired them anyways, we're going to fine you up to $50,000 every single instance. And so that's what it says. And that's in 1.460 and 4.70. Here's 1.470. Wimes writes, imposes a monetary penalty through civil enforcement against any political subdivision or law enforcement agency that employs an officer who formally enforced infringements, et cetera, et cetera, et cetera. So he's basically saying that because of these types of things, you're trying to interfere with federal enforcement. But this is absolute bull. Let's look again at California, the immigration sanctuary laws, this time AB 103, which was a 27 precursor to the Oregon law that I mentioned earlier, passed in 2021, that actually regulates some activity on facilities and where immigration agents can go, courthouses, things like that. Here, AB 103 requires the California Attorney General to conduct, quote, reviews of county, local, or private locked detention facilities in which non-citizens are being housed or detained for purposes of civil immigration proceedings in California. So California passed a law that says they're going to inspect federal facilities or facilities used by federal agents. I thought this was I thought this was dead in the water. I thought they were going much further than what anti-commandeering allowed, which is just an opt-out. Here, California took the position, they passed a law, they said, we're going to actively tell you we're regulating federal activity by requiring you to allow us to inspect this. Can you imagine Oh, man, there's so many different analogies of how I could see that not playing out in court, but this one got through. It requires California, this is additionally, it requires the AG and the state to review the conditions of confinement, the standard of care and due process provided, and the circumstances around the apprehension of similar immigration detainees, and then prepare a comprehensive report outlining the findings of the review. Short version, I'll kind of jump ahead on this. Only one part of that got struck down. Basically, to get the circumstances around the apprehension of the detention. So basically, the California AG was going to go to ICE and say, you have to tell us the circumstances of how this person was arrested. And the federal court said, you can't require them to give you nothing on this. And I think that was absolutely correct. Here, the California Peace Officers Association talks about the Ninth Circuit affirming this particular law, AB 103. The Ninth Circuit, they write, noted a distinction between those provisions of AB 103 that duplicated pre-existing inspection requirements imposed on state and local detention facilities, and any that imposed an additional burden exclusively on the federal government. And you can go all the way back to John Marshall and that McCulloch versus Maryland case where they were saying, oh, well, we're going to do a special tax on a national bank location or a branch, whatever you want to call it. And they're saying, well, no, you're singling out the federal government and attacking it as a way to thwart its existence, which I thought was awesome. I know things like this happened over the years in places in Brazil, for example. So it's a very creative approach. But the federal courts say, well, you can't do that. But you can impose some burdens to some degree, according to the federal courts now. It's in there now. This is a precedent. You can actually impose some burdens as long as it isn't exclusive to the federal government. That doesn't mean they can get away with imposing whatever burden they want, but California already had the same inspection requirements that they were going to impose on the federal government. So keep in mind, Missouri's Second Amendment Preservation Act includes no regulations at all on federal activities whatsoever. It does not require inspections of ATF agents or facilities. It doesn't require the ATF to report on anything. It does not require the state AG to basically ask a bunch of questions of the ATF and then report on how they're doing things. The feds aren't required to provide any information on any of the circumstances of arrests. It doesn't tell any federal agent what they can or cannot do. And Section 4601.470, they don't even say that federal agents can't enforce federal law. It does nothing. Instead, all they're regulating is the hiring activities of state and local law enforcement agencies and political subdivisions of the state. And those hiring restrictions those requirements have the same restrictions whether the person worked as a local cop or as a federal agent. So I think that there's absolutely no chance. I could be wrong on this one, but I think there's no chance that on review that part is going to get upheld. Now let's look again at California SB 54. This SB 54 is not the one that's regulating activity of the feds. It's the one that's saying that the state will not help in much of the federal immigration enforcement activity. And this is from, man, I forget what this one's from. Oh, this is actually from the Supreme Court docket. California's decision not to assist, this was a petition, I think, or review. California's decision not to assist federal immigration enforcement in its endeavors is not an obstacle to that enforcement effort. That's from the district court. Citing the district court, they said specifically, California's decision not to assist federal immigration enforcement is not an obstacle. So obstacle, they're not interfering by declining to participate. That is very important. Not helping is not the same as actively interfering, as Judge Wimes wants us to believe. The United States argument that SB 54, again, this is from the district court, makes immigration enforcement far more burdensome begs the question, more burdensome than what? The laws make enforcement more burdensome than it would be if state and local law enforcement provided assistance. No kidding. But refusing to help is not the same as impeding. If such were the rule, obstacle preemption, and that's what this is called. This is the legal doctrine, obstacle preemption. If preemption is when state and federal law have a possible conflict, and the state law is preempted. Basically, it means it's unconstitutional if it gets in the way of the federal law. Obstacle preemption is a version of that, where they're basically saying the state is putting up a physical obstacle to enforcement. That's definitely not happening under Missouri SAPA. And they're even saying the same about California SB 54. Refusing to help is not the same as impeding. If such were the rule, obstacle preemption could be used to commandeer state resources and subvert 10th Amendment principles. Now, here to the Ninth Circuit, they say, we agree with this. Even if SB 54 obstructs federal immigration enforcement, the U.S. position that such obstruction is unlawful runs directly afoul of the 10th Amendment and the anti-commandeering rule. I mean, there's so much precedent on this. It's almost a no-brainer, but I'm going to get to the creative part in this opinion in just a moment. Again, the Ninth Amendment say, ultimately, we conclude that the specter of anti-commandeering distinguishes the case before us from the preemption cases on which the U.S. replies. They listed a bunch of stuff saying, oh, well, there's other times that's been preempted, and they're saying, no. You've actually... I'm sure they knew what they were doing. They're just throwing stuff against the wall in the hopes they get a friendly judge that says, oh, okay, this sounds legit. Let's go with that. And I think that's what happened yesterday in Missouri. Those cases concern state laws that affirmatively disrupted federal operations by either mandating action contrary to the status quo or inaction. In each, again from the Ninth Circuit, in each state statute, they affirmatively instituted a regulatory scheme that conflicted with federal law, either by commission, for example, they write, by applying different standards or mandating affirmative action irreconcilable with federal law, or omission, by demanding inaction that directly conflicted with federal requirements. Again, they've said over and over and over, inaction is not the same as conflicting. The provisions banning support and penalizing agencies who hire people in violation of SAPA sure make it more difficult for the ATF. They keep telling us this is the number one reason we're suing is because it's making it more difficult. But again, that's not the same as actively and affirmatively interfering. Now, to be fair, there is this section that I mentioned before where Judge Wimes makes a little bit of sense here. No, I shouldn't understate it. There is actual sense here. And I guess if there was none and no one tried to impeach him, that would be a problem. Anyway, Section 1.440, he writes, imposes a duty on Missouri courts and law enforcement agencies to protect against infringements as defined under Section 1.420, which is the big one. In creating an affirmative duty, he writes, to protect against infringements, which seems natural to you and I. Of course, it's the duty of your law enforcement to protect and preserve under their oath to the Constitution and the Constitution of the state of Missouri. They have an oath, of course, but that's illegal. That is illegal under current precedent for a long time. So again, we're just working with what we got to work with. In creating an affirmative duty to protect against infringements, it effectively imposes an affirmative duty to effectuate an obstacle to federal firearms enforcement within the state. In imposing a duty on courts and state law enforcement to obstruct the enforcement of federal firearms regulations in Missouri, Section 1.440 violates intergovernmental immunity. I think that's probably legit under current Supreme Court precedent. That is probably going to get thrown out. I think if you have good judges that do things the right way on appeal and maybe up from there, I think that's going to end up being gone. But honestly, if it just takes out a statement, a feel-good statement, honestly, that I drafted in 2008, 2009, that is, it's in state law in Oklahoma as well. And I talked about this in an episode sometime last year. I'm like, the early versions of the stuff that we drafted, it may have been good at the time, but we learned quite a bit from then what works and what doesn't. And some of the early stuff we did was not good at all. Anyway, so I think this is going to get thrown out one way or the other. Now, here is the text of that section one more time. It is the duty of the courts It shall be the duty of the courts and law enforcement agencies of this state to protect the rights of law-abiding citizens to keep and bear arms within the borders of this state and to protect these rights from the infringements defined under Section 1.420. Now, each section is severable in Missouri. Severability is a very complex, long issue. But basically, it was written in this way where every little piece is its own section, because if a court strikes down one section and it doesn't implicate the rest of the law, you can get rid of that and still keep the prohibition on enforcement. So even though I think it's very likely and within reason under current precedent that they will lose on this particular section, it still doesn't change the fact that the rest of the act prohibits the state from helping the ATF enforce all kinds of federal gun control, past, present, and future. And now that brings me to the big one, Section 1.420. I think the entire opinion from Judge Wimes rests on his view of this. I think it is very unlikely that his view will carry forward in the higher courts on this, but it's possible. Let me just read it. The following federal acts, laws, executive orders, administrative orders, rules, and regulations shall be considered infringements on the people's right to keep and bear arms, as guaranteed by Amendment 2 of the Constitution of the United States and Article 1, Section 23 of the Constitution of Missouri, within the borders of this state, including but not limited to, and they talk about taxes, levies, fees, or stamps, registration or taxing of firearms, accessories, any act forbidding possession, ownership, use, transfer, firearm, accessory, ammunition, etc. So there's this whole long list of stuff. And Judge Wimes, he's basically saying it's unconstitutional for a state law to call a federal law unconstitutional. And I'm not kidding. This is literally what he's saying. It's not in those exact words, but he says Section 1.420 purports to categorize certain enumerated federal regulations set forth in the National Firearms Act and the Gun Control Act as infringements on the people's right to keep and bear arms as guaranteed by the Second Amendment. I agree with the fact that the National Firearms Act shouldn't exist. That's not Judge Wimes' opinion. That is not the Supreme Court's opinion. I agree with you probably that the Gun Control Act should not exist, that the ATF shouldn't exist, but the federal courts say both of them should exist. And Wimes' problem here is that Missouri is calling this a violation of the Constitution. Not in so many words. They're not actually saying it's a violation of the Constitution, but an infringement on those rights protected under amendment is basically saying, well, it's unconstitutional. It's beyond the Second Amendment. So he says it purports to call them infringements, yet notwithstanding its recitation, man, I have trouble reading sometimes, of infringements, the National Firearms Act and the Gun Control Act are, quote, presumptively lawful regulatory measures from, and I know a lot of gun people loved this case when it came out, but it was garbage on the original legal meaning of the Constitution in many ways. District of Columbia versus Heller. So he's literally citing a bad line from Heller that said NFA and the Gun Control Act of 1968 are, quote, presumptively lawful regulatory measures. So he's basically taking the position that because of this, it's preempted. Section 1.420, he's saying it's illegal to call the federal acts illegal. Some examples. So it's preempted. And preempted, for example, if you're talking about a conflict, if you've got an example of, let's say the feds require you to purchase health insurance and the state bans you from owning health insurance, it's impossible to comply with both at the same time. And that's really the test that the court system uses. It's only preempted in this type of a scenario if you create two totally opposite situations where it's totally impossible to follow both laws. If you follow one, you're automatically violating another one. But Missouri SAPA does not require anyone to violate federal laws on the right to keep and bear arms, federal gun control measures. It doesn't require anyone to do anything other than not help the feds enforce federal gun control. So merely calling something unconstitutional that the feds consider constitutional doesn't require anyone to break federal law. And then we have this again. Oh, here's how Judge Wimes put it. A federal law preempts a state law if the two are in direct conflict. A direct conflict occurs when compliance with both federal and state regulations is a physical impossibility. And that's the standard that the courts use. So, and that's the example that I was talking about. If the feds say you have to purchase health insurance and the state says, well, you're not allowed to purchase health insurance, then doing one or the other causes an automatic, impossible conflict where you're violating one law or the other. And that is not what's happening under Missouri SAPA. So he also says a direct conflict also occurs when a state law stands as an obstacle. But check out what the Ninth Circuit considers an obstacle, or maybe what it doesn't. Federal schemes are inevitably frustrated when states opt not to participate in federal programs or enforcement efforts. But the choice of a state to refrain from participation cannot be invalid under the doctrine of obstacle preemption, where, as here, it retains the right of refusal. This is on California Values Act, SB 54. This was an opinion in 2019, and this is the one. It went to the Supreme Court. The Supreme Court basically said, we're not going to hear this, and it's cool. Whatever the Ninth Circuit said on this stands. And this is what the Ninth Circuit said. The choice of a state to not participate cannot be invalid under the doctrine of obstacle preemption. But that's exactly what's happening in Judge Wimes. This is the biggest hole in what Judge Wimes had to say here. He's saying it's preempted under obstacle preemption, but all they're doing is opting out. So I think that's the weakest part of what he has. I mean, I think a lot of it is weak, but that doesn't mean that the other courts are going to agree with me. So but the choice of a state to refrain from participation cannot be invalid under the doctrine of obstacle preemption, whereas here it retains the right of refusal. Extending conflict or obstacle preemption to SB 54 would in effect dictate what a state legislature may and may not do. And that quote, dictate what a state legislature may or may not do. You may have heard at the beginning, I was going through some of these anti-commandeering cases, and that was the Murphy case in 2018, where they say the federal government cannot dictate to a state legislature what it may or may not do. And it goes even further. They said SB 54 may well frustrate the federal government's immigration enforcement efforts. However, whatever the wisdom of the underlying policy adopted by California, that frustration is permissible because California has the right, pursuant to anti-commandeering, to refrain from assisting with federal efforts. There is so much precedent on Missouri opting out. Now, 5 times, Judge Wimes, throughout his opinion, 24 pages, 5 times, he says calling this an infringement creates a confusion over what is legal under state or federal law. He says confusion over and over. He says, for example, such a statement, basically, again, referring to these federal acts as infringements and thus telling people that Missouri considers these to be unconstitutional. I agree with Missouri on this. Such a statement stands as an obstacle to the full purposes and objectives of federal firearms regulatory measures because it creates confusion regarding a Missouri citizen's obligation to comply with the taxation requirements of the National Firearms Act. Now, if confusion over what's legal on a state or a federal level and what's illegal is all that they need, then every state marijuana law would have been struck down by the federal courts. I need some water. I do like to talk, but sometimes I gotta step away for a moment. So if confusion over what's legal and what's not was the basis, this is absolutely absurd. Because anyone could make that case, and I know some people have tried to make that case regarding state marijuana laws, whether it's decriminalization or legalization, medical or recreational. Oh, well, this is a supremacy clause violation because you're telling the people something's illegal that's illegal. You're telling the people that this is legal, even though it's illegal on the federal level, according to the CSA, the Controlled Substances Act, and that confusion is what makes it a violation of the supremacy clause. Congressional Research Service had a little to say about this. Again, I will link to this and everything else in the show notes. They write, while an argument can be made that the decriminalization of medical marijuana under state law represents an obstacle to the accomplishment of the full purposes and objectives of Congress by creating confusion as to the permissible uses of marijuana, again, same argument, it is not the case that the federal objectives cannot otherwise be accomplished in the face of state marijuana exemptions. The federal government is still free to expend its own resources to implement and enforce its own law. And that's what it gets down to. No one's telling I am, other than me and you probably, we're telling the federal government stop spending money on enforcing laws that attack the right to keep and bear arms. But Missouri is not doing that. The feds, the ATF, is still fully free to spend whatever resources they have or want to spend. They really just want to get Missouri to participate because they know they don't have the resources. That's my quick aside. So again, the idea that it's confusing, there's all kinds of stuff. 37 states now legalize cannabis in some degree or another, to some level or another, medical or recreational, varying degrees in varying states, and that creates confusion over what's legal and what's illegal, and that is not something that the federal courts have ever even thought of. Well, maybe someone has, but it's not even reasonable to say that the federal courts are going to shut that down. The same goes for Missouri. It doesn't matter if they create confusion. So Judge Wimes then takes this view of obstacle preemption to the rest of SAPA. Again, this is the entirety of what his opinion actually rests on. It really rests on the fact that listing out a bunch of stuff as an infringement is unconstitutional. You can't do that. It creates confusion. It's illegal. It impedes federal agents. It interferes with federal enforcement. And so then the rest of the stuff in the act, which he actually agrees Missouri could do, which is not help, is then also illegal because it has nothing else left to reference. Because if you strike down the section that lists all the stuff that they're not going to enforce, then, well, it's gone. So the section defining federal gun control are infringements. That's his argument. It's an unconstitutional obstacle. That's his argument, partly because it creates confusion. And because of that, section 1.420 is illegal. And he says that here. Because 1.420 defines and categorizes certain federal acts, laws, executive orders, administrative orders, rules, and regulations as infringements, SAPA's other provisions are rendered meaningless without this definition. And again, actually, if they removed section 1.420, the list of stuff, then all of the references to that section would make the law meaningless. So he was actually, if he wanted to strike this down, this is really the only spot that he had a chance to do this. So I guess that's the question. Where does that leave stuff? And I know I've been going for a long, long time on this episode, but there's a lot of information. There's definitely going to be an appeal, and that's going to the 8th Circuit Court of Appeals. It'll go to a 3-judge panel first. Ron Calzone, my good friend over at Missouri First, he put it this way, quote, several weeks ago, we met with the new Missouri Attorney General, Andrew Bailey, and his top staff. I'm happy to report that he is totally, all caps, totally committed to defending SAPA all the way to the Supreme Court. That's good news. In fact, he actually seems excited about the opportunity. I mean, that would really build his street cred if he defended both the Second and 10th Amendment and did the right thing. So he's excited. Ron writes, particularly exciting to me is the fact that he really understands the 10th Amendment implications and long-term ramifications of this case. A win would make it very easy to get a lot more of these state laws passed. The fact that it got a loss on the first round is actually probably part of the political process. I think the people who filed this lawsuit, and maybe even the timing of this opinion had something to do with the fact that so many other states are considering legislation like this. And I know opponents are going to use that as a tool to say, oh, well, a federal court thinks this is unconstitutional. We should hold off on this and wait till it's done. So it'll probably slow down efforts to restrict enforcement of federal gun control in 2023. Although we can push through this, it's just going to take a lot of grassroots effort in Nebraska, in Kansas, in Ohio, in North Carolina, West Virginia, Iowa, and elsewhere. It's going to take a lot of work, but it's going to be much more difficult, and I think they know this. I don't think the feds expect to win in full. I think they will take maybe a little piece getting shut down and call it a moral victory or something like that, but they will be able to politically slow down the resistance by people in states by doing this, because many people think that the Constitution only means what the federal courts say it means until the courts change their minds, and we have to get away from that in the long run. So the lawsuit itself, again, it slows down these state efforts, and I think politically, win or lose, the administration, man, I hate these people, but for their goals, it's actually a very smart strategy. Now, my opinion, and again, I'm going to link to in the show notes the article I wrote about my prediction about the Trump loss on immigration sanctuaries from back in 2017. I think this is how it's going to play out. This is just my guess. Section 1.440, which creates an affirmative requirement to protect people, will get thrown out. It's just done. But that doesn't impact the rest of the law. So Section 1.420, that's the big one, which refers to federal gun control as an infringement of the Second Amendment, the rights and of the state constitution. I'm pretty sure that's going to stick around, like 90%, but it's not guaranteed. If it gets thrown out, then the whole law is done. Like, there is no chance. So it is, again, it's a little bit of a risky game, taking some chances. And when you think about it, though, none of the state laws, and the reason that this is not certain in my mind is because none of the other state laws that I'm referencing, the ones that have gone to court, some of them that have made it all the way to the Supreme Court, others that have not, none of them, whether it's immigration, whether it's the marijuana laws, none of the anti-commandeering laws, in none of these situations did any of those state laws refer to a federal act as a violation of the Constitution. So someone was smart and said, well, here's something that's different. Let's throw that out there. And I'm not sure if there's any precedent about this. And that's also part of the reason why our model legislation actually doesn't include that type of thing. Our Second Amendment Preservation Act does not actually include a text that says, in law, this is unconstitutional. It says we're not going to enforce federal gun control, and it lists out the stuff. So, and that's also why I think Montana, where the governor just told Merrick Garland that his state is banned based on HB 258, which we also supported in 2021, cannot and will not. It's illegal for the state to help enforce the new pistol brace rule. It's not as broad as the Missouri law, so there aren't as many things that they're banned from enforcing. But no one at the DOJ is trying to sue Montana because they don't have any attack vectors. That doesn't mean the Missouri law is not as good. It's just that it's open to a court case, and that means now we have to sit and wait and see how it plays out. So I think in the very, very unlikely situation that that section calling everything an infringement is held unconstitutional all the way up to the Supreme Court. If the Supreme Court takes that position, I would actually be very surprised. And even under the previous Supreme Court, the previous members, I would have been very surprised because all of this precedent comes from previous justices. So if that happened, Missouri would still have a way forward. They would have to amend the law. That's it. Very simple. They would remove references to specific federal gun laws or regulations as infringements. They would just not call it that. They'll just say, here are the things that we're not going to help enforce. Or like what we do in our model legislation, or what Arizona passed in 2021, they just basically say, we're not going to help enforce any federal gun law that does not exist concurrently in state law. And that's a great starting point if you think about it, because then every time you repeal a state gun law, you stop enforcing the concurrent federal gun law as well, or regulation, whatever. So the other approach would be to take the state marijuana approach and just start saying all of this stuff is legal, maybe tax and regulate. I mean, that's a whole different approach. But I can't really imagine playing out that way. But at the same time, I can, because I do not trust the federal court system to do the right thing. They've done the wrong thing for ages. We're talking about here, this opinion is citing the Heller opinion as upholding NFA and GCA as presumptively legal and constitutional. And maybe the judge has that wrong, and I'm just reading his words. I'm not an expert on Heller at all, but here James Madison put it this way. Dangerous powers not delegated may not only be usurped and executed by the other departments, but the Judicial Department also. So I'm a little wary about how this plays out. I'm very confident that Missouri will win on appeal or the next level, but it's not a slam dunk, and there are some areas that could get thrown out one way or the other. I don't actually have the time to go through the live chat tonight. I see so many people out there. Hunter, Liberty Revolutionary, my buddy in Missouri, Pavio, people in Missouri Freedom Initiative, who says Missouri SAPA will prevail. Take my word for it, folks. I mean, we can have positive thoughts all we want, and I'm with you. But if we don't understand exactly how they're approaching this, and that was my goal with this episode, no one's talking about all these details. If no one understands this and then they lose because the courts generally suck, then no one's going to know what to do about it after the fact. So this is a warning that it might lose. It most likely will only lose a very small part that does not change the impact of it. And then from there, we're a green light to really go nuts pushing this forward in more states in the coming years. And, well, never ending. And then we'll take further steps in Missouri as well, because in Missouri, then on top of it, what they need to do is start repealing a bunch of stuff of state gun control laws that are on the books. The ATF is a very handy printout, and we can get into that another time. But anyways, I appreciate you guys being here. If you support the work we're doing and you want to help us reach and teach more people about the Constitution and liberty and how to defend both when the federal government refuses to do so, which is constantly 24/7, 365, if you got a couple of bucks of that dirty government fiat, throw it our way. $2 a month. You can join us as a member over at 10thamendmentcenter.com/members. Nothing helps us get the job done more than the financial faith and support of our members. We have monthly options, lifetime, annual, 5-year, all that stuff. A bunch of people out here I can see just scrolling through the chat. There are a bunch of people here who are members, and I appreciate your support. Also, I will be publishing the blog post probably in about an hour or so over at 10thamendmentcenter.com/path-to-liberty. Continue leaving comments, reviews on Apple Podcasts, comments in the archive, smashing like buttons, all that stuff will help trigger algorithms and tell these mainstream platforms to show us to more people. Again, I really appreciate you guys being here. I hope you have a great rest of your Wednesday evening, and I hope to see you next time on the Path to Liberty.